All rise.
The Kosovo Specialist Chambers is now in session.
Good afternoon, Your Honours. This is file KCBC 2023-10, the Specialist Prosecutor versus Sabit Januzi, Ismet Bahtijari, and H.Shala.
I would kindly ask the parties to introduce themselves, and we will start today with the Specialist Prosecutor's Office. You have the floor.
Good morning, Your Honor. Good morning to the panel and to everyone in the courtroom. Today in the courtroom we have Deputy Specialist Prosecutor Vard Ferdinandese behind me to my right, behind to my left, Case Manager Lena Peterson, to my right, Prosecutor Taj Shahabudin, and myself, Associate Prosecutor John Devaney.
Thank you. Now I turn to the defense, and could you kindly add to your introduction who of your team is participating remotely or is present in the courtroom, and likewise for your client. And we will start with the defense for Mr. Bahtijari. Defense counsel, you have the floor.
Certainly, I appear as specialist counsel. My name is Felicity Gerry. Co-counsel is here, Marianne Karin. Legal associate, Yiching Leo, also present in court. The three of us are physically here. Online, you can see Philippa Stafford, our administrator, Cassandra Lagood and Ismar Ridzalovic, who are both our interns. Thank you.
Very well.
I do apologise. Is Katie here as well? And also today, joining us is Katie Delaney, our other administrator. Thank you.
Thank you. And I also note that Mr. Bahtijari is present in the courtroom.
He is.
Now I turn to the defense for Mr. H.Shala.
Good afternoon, Your Honours. Toby Cannon, Specialist Counsel, joined just today by Isabella Kiwan, Legal Associate. Mr. H.Shala is not present and he is not appearing remotely, having signed a waiver on his appearance yesterday.
Thank you, Defense Counsel. And now I turn to the defense for Mr. Januzi. You have the floor, Counsel.
Jonathan Aniston Rees, I am counsel for Mr. Januzi. Co-counsel present in court with me is Mr. Hugh Bowden. We are assisted also by the following who are in court as well: Mr. Muharremi Halalai, Ms. Alan Morgan, Ms. Zoe Lan, and Ms. Sally Harms.
Very well. And I note that Mr. Januzi is appearing via video link.
He is indeed.
Very well. Then, regarding the publicity of the hearings, I said it yesterday, but I will repeat it today. We intend to conduct these hearings in public, and we remind the parties that in case there's any need to go into private session, either for reasons of privacy or for avoiding disclosing any confidential information, I expect the parties to seize the panel immediately and we will decide on the matter. We have convened today's hearing to discuss and hear the submissions of the defense for Ismet Bahtijari on various issues pertaining to the plea agreement proceedings. And this is filing 628, Annex 1. The panel recalls that it will not issue today a decision on whether to approve the plea agreement, including on sentencing. The panel will issue such decision in due course. Today, the panel will proceed as follows. We will ask Mr. Bahtijari to confirm, pursuant to Rule 94, Paragraph 5a till d of the rules, whether his specialist counsel has discussed with him the terms of his plea agreement. We will also ask him whether Mr. Bahtijari understands the terms of the plea agreement and whether Mr. Bahtijari confirms the admission of the facts in respect of the charges contained in his plea agreement, and whether Mr. Bahtijari has agreed to his plea agreement voluntarily without threats or coercion, and whether Mr. Bahtijari understands the consequences of his plea agreement and waives his right to be tried under the ordinary trial procedure. We will see then, after that, if we need one more session, which could take place from around 3:30, or right away after the plea hearing. Just depends where we stand at that moment in time and if a break is necessary. And depending on how many issues there are still on the table, we would need to discuss. But that for all three accused. No. Very well. We will now proceed with the plea hearing regarding Mr. Bahtijari. And I see counsel for Mr. Bahtijari standing. You have the floor.
Thank you very much. Just very briefly, you will know that I asked for Ms. Liu to sit with Mr. Bahtijari. I'm told for security reasons that's not appropriate, but there will be someone to assist him to point at the screen when he needs to read. So if he gets stuck moving between your questions and what he needs to read, I understand someone will help him to look in the right direction.
Defense counsel, you were present yesterday throughout.
I was.
And no, it was an affirmative remark. And you have seen that we have assisted both accused in that way. And today we will even have, on the instruction of the presiding judge, the court officer assisting your client with the pointer at the screen. So both the court clerk will be standing next to him, and there will be, on my instruction, some guidance if necessary with the pointer. Then we can assure that your client is that the accused specialist counsel is Bahtijari. Counsel, can you confirm this?
It's actually Gary with a hard G, but yes, it is me. Thank you.
Gary. Gary?
Yes, thank you.
Very well. Before we begin, I ask the court officer to show on the screen the plea agreement with bearing filing number 628 Annex 1. And then, Mr. Bahtijari, I refer you to the document called Plea Agreement, which has been submitted to the panel as Annex 1 to filing 628, which is currently being shown to you electronically on your screen. And, Madam Court Officer, could you please go to page 10? Yes, and then the same page in the version, in the Albanian version. Yes, very well. And then I have a question for you. On the left-hand side of the screen, Mr. Bahtijari, there is a signature. Is that signature, and the court officer is pointing at the signature in the left corner. Is that your signature?
Pull.
Thank you. Mr. Bahtijari, I'm going to give you some instructions with regard to your microphone. Yeah? Every time you want to speak to the panel, you should switch on your microphone. And security is now so kind to indicate to you where it is. If you don't press the button, I cannot hear the translation of what you are saying into English, and then I don't understand you. So please be mindful, and I understand that it's not easy, but please be mindful to press the button if you want to talk. And if you're done with talking, press the button to take it out, to switch it off. No?
Yes.
And the reason that you have to switch it off is that for you, you can hear better what is being said. Yeah? So it's also important for you that when you don't talk, you switch it off. And I will try to assist you in this if I see that it's difficult. Very well. Then we go to the I see you standing, Madam Prosecutor, you have the floor.
Before we move on, I just note for the purpose of the record that the transcript doesn't actually reflect Mr. Bahtijari's answer to your question regarding paragraph 24.
Okay. Then I will ask, thank you very much. Then I will ask the question again. Mr. Bahtijari, the signature on the left-hand side of your screen, in the corner, and Madam Court Officer is pointing at it. Is that your signature?
Poor.
Yes.
Very well. Then we go to the right-hand side, to the right side, the page at the right side. Is the signature halfway the page, is that your signature? And I would ask, yes, and Madam Court Officer is pointing at it.
Yes. Yes, yes.
Thank you very much. And then I would like to go to page 20, let me see, the page 22 in the Albanian version. Yes, thank you. And page 11 in the English version. Thank you. Then in paragraph 26, Mr. Bahtijari, the first signature, is that your signature?
Poor.
Yes.
And then we go to the page at the right side of the screen. The first signature, from counting, looking at it from the start of the page, under the number 26. Is that your signature?
Poor.
Yes.
Confirming that. Now I will turn to your counsel, and we stay on these two pages. Defense counsel, can you confirm that on both pages it is your signature?
Yes.
Thank you very much. And then we go back to the two pages which were 10 and 21. Okay. Okay. Are those your signatures?
Yes, they are.
Thank you, Defense Counsel. Very well. You assisted Defense Counsel, no, you can remain, but it's an affirmation. You assisted Mr. Bahtijari in reaching this plea agreement, and these were your signatures we have just indicated.
Yes, that's correct.
Very well. Madam Prosecutor, or Mr. Prosecutor, I will turn to you to confirm for the record whether the signatures on the pages 11 and 23 in the English version, and I will ask Madam Court Officer to go to these pages. So 11 in the English version and 23 in the Albanian version. Yes. If you can confirm for the record that those signatures in the plea agreement are the signatures of the representatives of the Specialist Prosecutor's Office.
Yes, they are.
Very well. We note that. Then we may proceed. Mr. Bahtijari, I turn now to you. As you know, and certain your counsel is aware, the panel may approve the plea agreement as concluded between the Specialist Prosecutor's Office and your counsel on your behalf, if it's certified that certain conditions are met. This is what Rule 94, paragraph 5 of the rules require. I will therefore proceed to ask you some questions, and I will ask the SPO and also your counsel further questions where necessary in order to verify that all conditions of Rule 94, paragraph 5 are fulfilled. And I begin with Rule 94, paragraph 5 under A. In the plea agreement signed by you, it is indicated that you have discussed the terms of the plea agreement with your counsel and that you have entered the plea agreement after sufficient consultation with her. These are paragraphs 19 and 24-25 for your lawyer for the record. Is this the case?
Po.
Yes.
You confirm
Po.
this?
Yes.
Now I turn to Rule 94, paragraph 5, B and C. In this context, I will go through the terms of the plea agreement in order for the panel to assess that you understand the terms of the plea agreement, and not only that you understand, but also that you agree to those terms of the plea agreement. Mr. Bahtijari, do you confirm that you have carefully reviewed with your counsel every part of the plea agreement in a language that you understand, and that you understand the terms of this plea agreement as specified in paragraph 24 of this plea agreement? You may respond.
Po.
Yes.
Confirm that you
Po.
Yes. Yes.
say that you understand it, and I want to
E kuptoj, e kuptoj.
I understand it. I do.
and you also
Po.
understand.
Yes.
Po.
Yes. Yes.
Then we go now to Rule 94, paragraph 5 under C, which concerns the facts admitted by you, Mr. Bahtijari, which are underlying the charges that are in the plea agreement. And I will start with Annex 1 to your plea agreement, which contains the agreed factual basis. And while I read, Mr. Bahtijari, you may remain seated. It is filing 628 for Madam Court Officer, Annex 1, page 12, and in the Albanian version it's page 24. Mr. Bahtijari, I'm going to read out the agreed factual basis. So, the defendant, Ismet Bahtijari, accepts that he was part of a group which sought to induce witness 1 to refrain from giving evidence before the Kosovo Specialist Chambers through the promise of a benefit. In particular, members of the group acting at the direction of H.Shala, approached witness 1 at his home on 5 and 12 April 2023, respectively. During the 5 April approach, the defendant, Bahtijari, told witness 1 that he should withdraw his testimony before the Kosovo Specialist Chambers. During the 12 April 2023 approach, Januzi followed up on the first approach and relayed to witness 1 an offer that H.Shala and others would help him if he withdrew his testimony. Before and after the 5th of April 2023 approach, and before the 12th April 2023 approach, the defendant, Bahtijari, communicated and coordinated with other group members regarding their interactions with witness 1. Mr. Bahtijari, do you confirm your agreement on the agreed factual basis as I just read out to you?
Poor.
Yes.
Very well. Now, Bahtijari, for reasons, because the plea agreement refers to them, I will proceed to read the corresponding paragraphs from the confirmed indictment of the 10th of July 2024, which are paragraphs 8 and 9, 13 and 18, and 24, small I under I, double small I and 3 double small i's. And I ask in that regard the court officer to show on the screen the public version of the confirmed indictment of 10 July 2024, which is filing number 379, Annex 3. And please, yes, indeed, in the English and in the Albanian version. And I will now read out, Mr. Bahtijari, the paragraphs 30, the paragraphs which are mentioned in the paragraph 5 of the plea agreement. And for the record, I repeat them. I will read out 8 and 9, the paragraphs 13 till 18, and 24 subparagraphs I under I, double I, and 3 double I. Very well. Madam Court Officer, could you please bring us to paragraph 8? For both versions, yes. Mr. Bahtijari, do you see on your screen the paragraphs 8 and 9?
Poor.
Yes.
On the 5th of April, this is paragraph 8, on the 5th of April 2023, H.Shala called Januzi. Bahtijari then also called Januzi. We go to paragraph 9. Then, after calling and verifying that witness 1 was at home, Bahtijari came to witness 1's home. Bahtijari told witness 1 that H.Shala had recently approached him and sent him to tell witness 1 that he should withdraw his testimony. Madam Court Officer, please bring us to paragraph 13 in both versions. And because I will be reading till paragraph 18, I think, yeah, we can go a little bit higher. And I ask you that when we are near paragraph 18, when we are paragraph 16, I will ask you to to change what we are seeing on the screen. Okay, very well. Paragraph 13. Later on, 5th April 2023, after Bahtijari had visited witness 1, H.Shala and Januzi, and separately Januzi and Bahtijari, engaged in numerous text and phone contacts, including contacts between H.Shala and Januzi, to coordinate an in-person meeting that same evening. In the days that followed, H.Shala and Januzi, amongst others, remained in contact, including connecting by phone at least 4 times between the 6th of April and the 9th of April 2023. Paragraph 15. On the 12th of April, shortly after calling H.Shala, Januzi went to witness 1's home. At witness 1's home, Januzi told witness 1 that H.Shala had asked Januzi to follow up on Bahtijari's visit and to find out what witness 1 planned to do and how the matter of his testimony could be addressed. Paragraph 16. Specifically, Januzi told witness 1 that H.Shala had asked Januzi to convey the message that if witness 1 withdrew his testimony, then H.Shala and unnamed others would provide him with help. Witness 1 responded that if H.Shala and or the others brought him 200,000 euros, they would have a deal. We go to paragraph 17. Yeah, thank you, Madam Court Officer. Witness 1 did not confirm or deny being a witness. Januzi said he would tell them what witness 1 had said. Paragraph 18. Shortly after his 12 April 2023 visit to witness 1, Januzi again called H.Shala. And now, please, Madam Court Officer, bring us to paragraph 24. Thank you. Paragraph 24, small I under a small I. On 5th of April 2023, at H.Shala's direction, Bahtijari approached witness 1 and, small I, told witness 1 that witness 1 should withdraw his testimony in KSC proceedings. On 12 April 2023, at H.Shala's direction, Januzi approached witness 1 to follow up after Bahtijari's earlier approach and to relay the offer that H.Shala and unnamed others would help witness 1 if he agreed to withdraw his testimony. And then three little I, before and after approaching witness 1, Januzi and Bahtijari communicated and coordinated with each other and H.Shala. This was the content of the paragraphs in the confirmed indictment of the 10th of December 2024. And I will now turn to paragraph 5 of the plea agreement, which states as follows. Ismet Bahtijari and the prosecution agree. Thank you, Madam Court Officer, for bringing us to paragraph 5. Ismet Bahtijari and the prosecution agree that if the prosecution were to proceed with evidence, the facts and allegations as set out in paragraph 8 and 9, 13 till 18, and 24, subparagraphs small I under I, double I, and three double I of the indictment dated 10 July 2024 would be proven beyond reasonable doubt, and that those facts are true and correct and not disputed by Ismet Bahtijari. Mr. Bahtijari, I turn to you. Do you confirm your agreement with this statement that I just read out to you?
Pour.
Yes, I confirm.
Very much. Now we turn to the nature of the charges. Mr. Bahtijari, the panel also wants to ensure that you are fully aware of the charges contained in the plea agreement. And for that purpose, I will read out to you paragraphs 3, 8, and 9 of the plea agreement itself. Madam Court Officer, yes, thank you very much. We are already there in the two versions. Paragraph 3 reads as follows. Do you have it in front of you? Mr. Bahtijari, do you see it?
Pour.
Yes.
Ismet Bahtijari agrees to admit guilt before the trial panel pursuant to Rule 94 of the rules in relation to counts 2 and 3 of the indictment dated 10 July 2024 to the extent they are alleging in count 2 obstructing official persons in performing official duties by participating in the common action of a group between at least the 5th and the 12th of April 2023, punishable under the Kosovo Criminal Code, KCC, Articles 17, 21, 28, 33, 35, 401, paragraph 2 and 5, and Articles 15, paragraph 2 and 16, paragraph 3 of the law on the Specialist Chambers and Specialist Prosecutor's Office, referred to as law, and in count 3, intimidation during criminal proceedings by means of a promise of a gift or any other form of benefit between at least the 5th and the 12th of April 2023, punishable under KSC Articles 17, 21, 31, 33, 35, and 387, and Articles 15, paragraph 2, and 16, paragraph 3 of the law, including all modes of liability alleged therein. Paragraph 8 reads as follows. Do you have it in front of you, Mr. Bahtijari?
Pour.
Yes.
Bahtijari fully understands that he is admitting guilt in relation to counts 2 and 3 of the indictment as described above, and specifically admitting his conduct as set forth in paragraphs 8 and 9, 13 and 18, and 24, subparagraphs small I under I, double small I, and three small i's of the indictment, and as further described in the agreed factual basis. And then we turn to paragraph 9, and that's a long paragraph. And it reads as follows. Ismet Bahtijari understands that if a trial were held, the prosecution would be required to prove the following elements of Articles 21, 387, 401, paragraph 2 and 5, beyond reasonable doubt. And for count 2, that are the following elements. Participation in a group, which by common action, KCC Article 401, paragraph 2, obstructs or attempts to obstruct an official person in performing official duties, KCC Article 401, paragraph 2. The offense was committed against a judge, a prosecutor, an official of a court, prosecution officer, or a person authorized by the court and prosecution office, or a police officer during the exercise of their official functions. KCC Article 401, paragraph 5. Awareness of and desire to commit the act, or awareness that a prohibited consequence can occur as a result of the act or omission and accession to its occurrence. And this is KCC Article 21. We turn to count 3 and to its elements. Under A, the use of force or serious threat or any other means of compulsion, a promise of a gift or any other form of benefit, which is KCC Article 387. And to induce another person to refrain from making a statement or to make a false statement or to otherwise fail to state true information to the police, a prosecutor, or a judge, and such information relates to obstruction of criminal proceedings. And this is KCC Article 387. And then as the last element, awareness of and desire to commit the act or awareness that a prohibited consequence can occur as a result of the act or omission and accession to its occurrence. And this is KCC Article 21. Mr. Bahtijari, I turn again to you. Can you confirm that you agree to the above charges?
Pooh.
Yes.
Now, as regards admission of guilt, I refer to paragraphs 3 and 7 of the plea agreement, and I will read out to you paragraph 7, but not paragraph 3. It remains relevant also in this context, but I have just read it out, so I will not repeat it here again. So paragraph 7 in the English and in the Albanian version. Do you see them, Mr. Bahtijari, on your screen?
Pooh.
Yes.
I will read it out. Ismet Bahtijari agrees to make an admission of guilt in relation to the charges identified at paragraph 3 above, because he is in fact guilty and acknowledges his guilt and accepts full responsibility for his conduct as described in the agreed factual basis. Mr. Bahtijari, do you confirm your agreement on this point?
Pooh.
Yes.
Thank you. Mr. Bahtijari, the panel takes note of your agreement on this point, and I will formally ask you to enter a plea later on in this hearing. Now we turn to the term of the sentence. Madam Court Officer, could you please bring us to paragraph 11? Now, in terms of the sentence, Mr. Bahtijari, I read in paragraph 11 of the plea agreement bearing filing number 628, paragraph 1, that you agree on the imposition of a sentence of 2 years imprisonment. Mr. Bahtijari, Do you confirm that you agree on the imposition of a sentence of 2 years imprisonment?
Pour.
Yes.
Thank you. Now I have a question for defense counsel. In the previous version of the plea agreement, bearing filing number 618, Annex 3, paragraph 10, dated the 6th December 2024, Mr. Bahtijari agreed to the imposition of a sentence of imprisonment up to and including 10 years. Madam Court Officer, could you bring this document on the screen? But not in public. Sorry, Defense Counsel, for making you stand. Please.
Not at all, I'm fine.
Okay. Very well. As just said, in the plea agreement as it stands, Mr. Bahtijari agrees to the imposition of a sentence of 2 years imprisonment. Could you further clarify the change of position of Mr. Bahtijari in this respect? And you have the floor.
In the previous plea agreement, we did not agree 10 years. What we agreed with the prosecution was that the range was 0 to 10, and then there was a recommendation from the prosecution of 2 years. The current plea agreement contains an agreement for 2 years. The previous plea agreement used some specific language to refer to the Kosovan Criminal Code that allows this court to go below the statutory minimum of 2 years. So the previous plea agreement tried to capture that in a way that we understand did not find favour with this court. The current plea agreement is made with the agreement of the prosecution and Mr. Bahtijari so that it can comply with Rule 94 in the way that Rule 94 has been expressed by this court. We hope that provides the relevant assistance.
Defense Counsel, for now this will do. Thank you.
Thank you.
And for the record, the filing, yes, is Annex 3 to filing 618, yes. Mr. Bahtijari, I have 2 questions for you. And you may, of course, confer with your counsel before you give your answer. Can you confirm that you have been fully informed that the panel will not take a decision today on the plea agreement, including the sentencing, despite the submission of the new plea agreement? And second, knowing that, do you confirm that you agreed to the imposition of a sentence of 2 years of imprisonment as per the plea agreement you signed this week? You have the floor.
He may not understand you have the floor. It might
Pour.
be...
Yes.
This is your role to take care of his interests, like we do.
Thank you very much.
The plea agreement also states in paragraph 16 that in exchange for your admission of guilt, the SPO will recommend to the trial panel a sentence of 2 years imprisonment and recommend that you be given credit for the time served in the custody of the Kosovo Specialist Chambers. And as per paragraph 16c of the plea agreement, the SPO also agrees to withdraw count 1 against you, Mr. Bahtijari. Do you confirm that?
Poor.
Yes.
Let me now turn to paragraph 12 of the plea agreement, which concerns the legal remedies. Thank you, Madam Court Officer, for pulling up the plea agreement. And yes, we can go to paragraph 12. Of the plea agreement, filing 6 to 8, Annex 1. Thank you. Yes. In terms of legal remedies, Mr. Bahtijari, I will read out the relevant parts in paragraphs 12 and paragraph 16 of the plea agreement, which concern your ability to appeal the conviction or sentencing. And as a preliminary remark, I note that the SPO has withdrawn its request for reconsideration and leave to appeal of decision 612. And this withdrawal was in filing 631, dated the 17th of December 2024. And as a result, paragraph 12 of the plea agreement is to be amended in order to conform to decision 612. The panel will issue the necessary order in due course. I wish, however, to ensure that you understand how this impacts your plea agreement and that you agree with this change. And you may, of course, confer with your counsel before you give your answer. And in addition, as per the terms of paragraph 12 of the plea agreement, I would also like you to confirm that you will not move to withdraw your guilty plea or appeal your conviction pursuant to your guilty plea. Mr. Bahtijari, do you understand and agree that, should the panel approve the plea agreement and set a sentence which accords with the terms of the plea agreement, you will be precluded from pursuing appellate remedies against said decision? And that you will not move to withdraw your guilty plea or appeal your conviction pursuant to your guilty plea? And I would like you to confirm that you understand both of the above points, Mr. Bahtijari. And I repeat, you may also confer with your defense counsel before you give your answer. Yes, you have the floor, Mr. Bahtijari.
If you could repeat the question, please. I wasn't able to understand.
I wonder if I may assist.
Now, defense counsel, you may confer with your client, and we have a procedure for that in place, but I prefer that I ask the questions and he replies to them. So
Absolutely.
So I don't...
If I may...
No, if you want to confer with your client, to explain it.
No, I would like you to break it down into two questions. You asked two questions in one. The first one was whether he would not withdraw his guilty plea, and the second one was that whether he would not appeal. So all I'm asking you is to ask the questions separately, and then I think he will understand, please.
No, we are not going to proceed. We are not going to proceed like this. If you want to explain it to him, you may explain it, but I think they have to go together.
Okay, so perhaps if the question could be asked in this way, that this question contains two things. One is withdrawal of your guilty plea, and the other is the appeal. I think that will help him to understand.
Okay, we can proceed, but they're not separate. They go together.
I understand your
No,
position.
but therefore, defense counsel, we cannot break them up. Yes, but it's enough for now.
I suspect, having heard me, he'll understand the question now. Thank you.
Mr. Bahtijari, I will repeat the question for you. Do you understand and agree that should the panel approve the plea agreement and set a sentence which accords with the terms of the plea agreement, you will be precluded from pursuing appellate remedies against said decision? And if you understand and agree that you will not move to withdraw your guilty plea or appeal your conviction pursuant to your guilty plea.
You.
No.
You don't understand. Then I propose that...
You gör nog i början sen.
No, I meant I will not. I will act accordingly to the instructions and what you just read.
On the SPO side, I note paragraph 16 of the plea agreement, and the same preliminary remark applies to paragraph 16b under little I of the plea agreement. In terms of amending.
Yes, we note Your Honor's submission, yes.
Very well. Mr. Bahtijari, we now move to Rule 94, paragraph 5c, according to which the panel must be satisfied that you entered the plea agreement from your own free will, Mr. Bahtijari. And I note that in paragraph 24 of the plea agreement, Madam Court Officer, could you please bring us to paragraph 24? Thank you. It is stated that no one, you state, that no one has threatened or forced me in any way to enter into this agreement, and I have entered into this plea agreement freely and voluntarily. Your counsel also submits in paragraph 19, could we please go to paragraph 19? That you entered into this plea agreement freely and voluntarily, that no threats were made, and that the only promises made to you are those set forth in this agreement. Mr. Bahtijari, could you confirm before the panel that you have agreed to this plea agreement voluntarily, without threats or coercion?
Yes, I confirm.
Thank you. Let us now move to the next point. The panel wants to confirm that you, Mr. Bahtijari, understand the consequences of the plea agreement and that you waive your right to be tried under the ordinary procedure as per Rule 94, paragraph 5 of the rules. And on this point, Mr. Bahtijari, there are several steps, and I will walk you through them. First, I will read out paragraph 17a till F and paragraphs 18a and B of the plea agreement, as these paragraphs summarize the rights you waive and the rights you will still retain pursuant to the terms of the plea agreement. Mr. Bahtijari, by virtue of this plea agreement, you will be giving up, in whole or in part, the opportunity to exercise the following rights. Paragraph 17, the right to plead not guilty and to require the prosecution to prove the charges in the indictment beyond reasonable doubt at a fair and impartial public trial. The right to be tried in your presence and to defend yourself through a special counsel at such trial. The right to raise defenses and grounds for excluding criminal responsibility and to present admissible evidence at such trial without prejudice to the right to make submissions and present evidence with regard to sentencing. The right not to be compelled to testify against yourself or to confess guilt. The right to examine or to have examined the witnesses against you and to obtain the attendance and examination of witnesses on your behalf under the same conditions as witnesses against you, without prejudice to your right to examine any witnesses that may be called to testify, and your right to call witnesses and have them examined on your behalf at any proceedings with regard to sentencing. And then under F, the right to pursue appellate remedies with regard to conviction or sentencing as specified in paragraph 12 of the plea agreement, which I just read out. Mr. Bahtijari, can I have your confirmation that you understand this and that you waive these rights?
I confirm.
Very well. Thank you. Second, pursuant to the terms of the plea agreement, Mr. Bahtijari, and these are paragraph 18 under A and B. Yeah, thank you, Madam Court Officer. Yes. It is understood that you retain all other rights, including, in particular, the right to be represented by specialist counsel at all stages of the proceedings and to communicate freely with such counsel in confidence, and the right to submit any information or evidence relevant for the determination of the sentence pursuant to Rule 162, paragraph 1 and paragraph 5 of the rules. Before I turn to ask Mr. Bahtijari if he understands the consequences of the plea agreement and waiving his right to be tried under the ordinary procedure, I would like to give an opportunity to the SPO and Council to make any other observations or submissions that they deem relevant, including as regards Rule 94, Paragraph 5 under E and F. So, first, Specialist Prosecutor's Office. You have the floor, Mr. Prosecutor.
Your Honor, having listened carefully to the colloquy, it's the SPO's position that the requirements under Rule 94.5 at this point have been met, including E and F, and the SPO has no further comments at this point.
Thank you. Defense Counsel, you have the floor.
I agree and have no submissions to make.
Thank you. Mr. Bahtijari, may I ask you to confirm again, having heard that there are no further submissions from the side of the SPO and the Council, can you confirm again that you understand the terms and consequences of the plea agreement and that you do not wish to change anything in the plea agreement that you have signed?
Poor.
Yes. Yes, I confirm.
You. Mr. Bahtijari, I will now ask you to stand up. Please stand up. And then I will ask you to change your initial plea. During the hearings of the 9th of October 2023 and the 12th July 2024, you pleaded not guilty to the charge of obstructing official persons in performing official duties by participating in the common action of a group under count 2 of the confirmed indictment of the 4th of October, filing 10. In case then 10. And the charge of intimidation during criminal proceedings under count 3 of the confirmed indictment of the 10th of July 2024, case 10, filing 379, Annex 1, respectively. Are you ready to change your initial plea of not guilty?
Nog pek op tape.
I
Question, can you please repeat it?
During the hearings, already more than a year ago, you pleaded not guilty to the charges, and I'm going to ask you now, if you confirm that you will plead guilty. And I want to know if you are ready to change your plea.
Poor.
Yes.
If you have difficulty standing, please sit.
Popo en Rai.
I will change my initial plea.
I will proceed to read out counts 2 and 3 as reflected in the confirmed indictment of the 10th of July 2024 and ask you to enter a plea for each one of them. Mr. Bahtijari, you may be seated. Count 2. Obstructing official persons in performing official duties by participating in the common action of a group between at least 5 and 12 April 2023, a criminal offense against public order punishable under Articles 17, 21, 28, 33 and 35 and 401 paragraph 2 and 5 of the Criminal Code of the Republic of Kosovo of 2019 and Articles 15 paragraph 2 and 16 paragraph 3 of the law. To this count, Mr. Bahtijari, how do you plead? Guilty or not guilty?
Faitor.
Guilty.
Thank you. I proceed to count 3. Intimidation during criminal proceedings between at least the 5th and the 12th of April 2023, a criminal offense against the administration of justice and public administration, punishable under Articles 17, 21, 31, 33, 35 of the Criminal Code of the Republic of Kosovo of 2019, and also 387 of the same code, and Articles 15, paragraph 2, and 16, paragraph 3 of the law. Mr. Bahtijari, how do you plead to this count? Guilty or not guilty?
Faitor.
Guilty.
Well, we proceed with the topic of reparations. The panel will turn to you, Defense Counsel, if you want to make any observations on the matter.
We have made some written observations that there should be no financial cost in any respect as regards Mr. Bahtijari, so we include that in that any fine or costs of proceedings or reparations. But in the light of the oral order that you made yesterday, that there ought to be inquiries with potential victims as to whether there are any victims who seek reparations at all or to whom reparations would be applicable, we accept that you have ordered that that inquiry should be made. You've made an oral order to that effect. And thus we cannot make full submissions about reparations until that inquiry has been made. So what I say now are set out preliminary submissions that we would submit that this is not a case to which reparations is applicable, but we reserve our right to make full submissions on the question of reparations once the oral order has been complied with.
Thank you, Defense Counsel. That indeed clarifies, because as you rightly said, you made submissions regarding monetary penalties, that there should be no financial consequences, you said, but we did not see anything explicitly about reparations. And we saw in, what is it, paragraph 15, if I'm not mistaken, that, yeah, it's in all the plea agreements that it would be addressed at some point. So I just wanted to be sure that we have everything on board, and I've heard what you said with regard to the outcome of the oral order of the panel.
Thank you very much. I've nothing further to add at this stage, and we hope to assist you at the appropriate moment.
Thank you. Then the floor is for the Specialist Prosecutor's Office. Mr. Prosecutor.
Yes, Your Honor. We have very little to add. We are in agreement as to the submissions being premature at this point until we know whether there will be participating victims or not, which is set in line with the modalities of the oral order given by the panel yesterday.
Thank you, Mr. Prosecutor. Then we are at the point of sentencing submissions. We note the written submissions on sentencing. And before I give the floor to make any addition to that to both Defense Counsel and to the Prosecutor, I will first seek clarification from Defense Counsel, and then we can have the moment for additional submissions. Defense Counsel, Mr. Bahtijari confirmed earlier in this session that he agreed to the imposition of a sentence of 2 years imprisonment as per paragraph 11 of the plea agreement, as it stands now, this week's. And could you clarify the position of the defense as expressed in court yesterday during the preliminary matters that, and I quote, and I will also give you the references, Mr. Bahtijari's position is that he should be released immediately, so any further delay is of a complete prejudice to his position. And this position is also expressed in your sentencing submissions, filing 620, paragraph 70 of the 6th of 6 December 2024, and that is a confidential one, but because it's the same like yesterday, we feel at liberty to say that in open court. And what the panel would like to know, if you could clarify and further reason your position on this.
Yes, I apologise if it was phrased badly yesterday. We're not seeking to go behind the plea agreement at all, but we hope that our sentencing submissions will find favour in the exercise of your discretion.
Thank you, Defence Counsel. I will give you first the floor for any additional submissions. We have taken note of the written submissions, and then we will give the floor to the Specialist Prosecutor's Office. Defence Counsel, please.
Thank you. I'll just get a little closer to the microphone with my paperwork, and to reassure you that I don't propose to take terribly long, but I do wish to put some matters orally to this court. Because of the nature of some of the material, may I first ask to go into private session? That will enable me to make full submissions without reference to confidential material in public session.
We will go into confidential, into private session, and I will ask you to further reason why the whole session should be in private, but we will discuss that in private.
Thank you.
Madame Court-Officier, could you bring us into private session, please?
Your Honours, we are now in public session.
Thank you, Madam Court Officer. Please proceed, Defence Counsel.
May it please the Court, I adopt the words of Mr Devaney from the Prosecution Officer yesterday that he used. In our submission, Mr Bahtijari is not the beginning, the middle or the end of this offending, but is at the lowest possible level of culpability. I have mentioned his health in a status conference publicly back in March of 2022, so I invite you to reach this conclusion. He is a poor, sick, old man, older than his years, who was acting under direction. We accept, as a matter of law, this is a case where the court will consider general public deterrence. However, we submit in his case that that is accounted for in the plea agreement. Our submission is there is absolutely no need for specific deterrence to Mr Bahtijari. They are two different legal principles, general deterrence to the public, specific deterrence for him. There is no need in our submission to deter a sick, old man suffering the issues that we have raised in private session. Our observation on the offences are as follows. These are two offences, two charges, for one event or one set of events. I'll just pause while the security change over. Thank you. These are two charges for one event or one set of events for him involving one visit and a few calls. There is a clear plea agreement that this was an offer of a benefit and not threats. His plea agreement was made before any witness had to come to court, and indeed just before the trial started. On the 5th of April of 2023, Mr Bahtijari was acting under direction. Mr Devaney said yesterday, on page 75 of yesterday's transcript, quote, "The first approach did not work," close quotes. In our submission, that makes Mr Bahtijari's role even smaller. Witness 1, as you know, is able to describe Mr Bahtijari's demeanour. We've set that out in private session. As we have set out in private session, what we say about those matters that plainly reduce Mr Bahtijari's culpability. This was a single visit, save for minimal phone contacts. After the 5th of April of 2023, Mr Bahtijari played no further part. He was not involved in the 12th of April 2023 events. He was plainly not himself offering any benefit or gift. He has created no aggravating features for the offending. He has no criminal convictions. He cooperated on arrest and answered questions when he was interviewed and did not seek to run an alibi. I now move to his mitigation, which in our submission is substantial. Of course, we invite the panel to take into account all of our sentencing submissions and all of the confidential annexes that we have referred to in private session. So what I say now is a mere summary for the purposes of the principle of orality, so that his mitigation can be heard without waiving private matters. On paper, he doesn't look very old. There might be many people in this room about the same age, but he is plainly older. You have details about the potential for his longevity or the shortening of his life, which in our submission wholly mitigate this sentence on their own. But on top of that, he is a father and a good father, a loving father and a loved father. He is a grandfather, a loving grandfather and a loved grandfather. He is a community man of exceptional good character, much loved and supported by his community. When we visited, we were invited to a funeral so that we could pay respects on his behalf, so that he could reach out and still pay his respects to his community from here, because he is not at home. He is the centre of his family's world. It's sometimes hard to understand, very close families, the effects that can happen from one person in a close family being removed. You can understand that from the evidence that you have from us for the purposes of sentencing Mr. Bahtijari. He is hard-working. He has worked all his life to support his family. He is a survivor of war, in which it is public knowledge that people in his location survived genocidal attacks. You have information about what happened to his village. It is public knowledge that a broken Serbian tank still stands on the hill in his village as a permanent reminder, as do the painted words on one of the buildings, overshadowing that village where that tank and others rolled into that village as the people of that village escaped to the mountains and lived in the mountains at risk of genocidal attacks and death. It is a beautiful rural village. These people have survived as a close community, and he has played his part in rebuilding that village. Those villagers, it is publicly known, left twice, and you have the ages of his children. Frankly, how a baby would be kept alive in those conditions in the mountains is true respect to these parents of those children, and including Mr. Bahtijari. He has his community's full support. He rebuilt that village by hand, and indeed you have descriptions of what happened to that village and what happened to the livestock and what happened in his own garden and the bravery that he showed in his own house and garden, and the descriptions of where everyone had to live until that house was rebuilt. His family and community ties could not be stronger.
Defense Counsel, Mr. Bahtijari, is there anything we can do for you?
Scham.
I've nearly finished.
I didn't hear the answer of Mr. Bahtijari.
I don't need anything, thank you.
Very well.
As you know, his family are significantly affected, and they have set that out in moving matters which I've dealt with in private session. You have the impact of these proceedings both on him and on his family, and the descriptions from his community members that enable you to reach this conclusion. He is needed at home. He has suffered hardship in detention over and above other people in his position. His situation is extraordinarily sad. He needs to be at home with his family for whatever time he has left. We submit that should be immediate. We asked for this matter to be listed on the 10th of December. From that date to today would account for any days to be served for any financial cost. We urge you to find a sentence that can sentence him in a way that allows for his immediate release on this day, the 19th of December 2024. We understand that that places this court under pressure. If you cannot accede to that request, the most I can ask is you release him as soon as possible. Those are our submissions.
Thank you, Defense Counsel. I will give now the floor to the Special Prosecutor's Office, and you have heard the request with regard to the immediate release, and I ask you also to give your submissions on that.
Yes, Your Honor. The submission of the Specialist Prosecutor's Office is that 2 years is the agreed-upon sentence between the parties in this case. That sentence is also the lowest sentence of any of the accused in this case. It is a fair and a just sentence, and it encompasses, to the extent appropriate, the mitigating factors relied upon by the defense. The agreed-upon sentence factors in the accused's admission of guilt and the timing of that admission, the degree of cooperation given by the accused, which was limited admissions on the very eve of trial, the character of the accused, Mr. Bahtijari's role in the offenses as compared to the other accused, and to the extent appropriate, the medical submissions of the accused. Regarding the 5 April approach, it is important to understand exactly what is at stake. From the agreed-upon facts, it reads as follows. During the 5 April 2023 approach, the defendant, Ismet Bahtijari, told witness 1 that he should withdraw his testimony before the Kosovo Specialist Chambers. If you go to the agreed-upon paragraph in the indictment, which comes from paragraph 9, Bahtijari came to witness 1's home. Bahtijari told witness 1 that H.Shala had recently approached him and sent him to tell witness 1 that he should withdraw his testimony. So, essentially, witness 1 is approached in his home and told that former KLA Commander H.Shala says that you should withdraw your testimony. At this point, no offer of a benefit, just withdraw your testimony. This statement must be considered in the context of the palpable, persistent, and pervasive climate of witness interference in Kosovo. The SBO would submit that the only logical conclusion to such a statement is fear and concern. Fear and concern for yourself and for your family, which is exactly what happened in this case. And this is akin to the fear opined that related to Mr. Bahtijari, and this fear is harm. And this result is attributable not just to Mr. Bahtijari, but also to Messrs. H.Shala and Januzi, who both set this approach into motion. Your Honor, at this time, we would ask to go into private session to address the other submissions of counsel.
Thank you, Mr. Prosecutor. Madam Court Officer, can you bring us into private session, please?
Your Honours, we're in public session.
Thank you. You may proceed.
Yes, Your Honor. Offenses against the administration of justice constitute a grave challenge to the security and integrity of judicial proceedings. Such offenses can undermine the discovery of truth and impede justice.
Could the speaker please slow down for the purpose of interpretation? Thank you very much.
Prosecutor, please slow down your pace for the purposes of translation.
Of course, Your Honor.
Thank you.
The impact of these offenses as part of the continuing pervasive climate of witness interference cannot be overstated. That protected witnesses at the KSC can be repeatedly approached and subjected to criminal conduct has a potential chilling effect on the public confidence in the effectiveness of the KSC orders and decisions, including those related to protective measures. Deterrence in the form of a significant sentence protects this confidence. Your Honor, Your Honors, the panel, we would like, the SPO responds now briefly to a point made by the accused. Counsel for Mr. Bahtijari references witness statements disclosed by the SPO to say that on April 5th, during the April 5th, 23 approach, Mr. Bahtijari was in fear. Therefore, the SPO would ask that you consider those same statements and fear that the accused collectively caused to the victims that they targeted. In the final analysis, the sentence of 2 years in this case is the just, agreed-upon sentence, and it should be accepted by this panel. Thank you.
Thank you, Mr. Prosecutor. Is there something explicit you would like to say with regard to the request for immediate release today?
Your Honor, as part of the plea agreement, the SPO does support giving credit for time served. So we do stand by the 2 years, although noting counsel is free to pursue other remedies and that this does not represent significant additional time from the present for the accused.
Thank you. Defense counsel, I will rule right away on this issue. We said it earlier today, and I will repeat it now for reasons of clarity. The panel will not issue a decision on the plea agreements, including on sentencing. So that means that we will proceed with the course we have indicated. So there will be no release today.
I understand there will be no release today. I repeat my submission that we invite you to release him as soon as possible. That's as high as I can put it. And I wonder if I might just briefly respond to what the prosecution have submitted in a couple of respects.
Yes, you may, and we have noted your submissions, and we will proceed as indicated with this procedure. And of course, and after you, the prosecution will be in the possibility, will be put in the position, and if all views are exchanged, then we finalize. So please proceed.
Yes. Did you want me?
You may react to the submissions of the Specialist Prosecutor's Office.
Thank you. I was just checking I understood you correctly. Thank you very much. So we're grateful to the prosecution for recognising Mr. Bahtijari's cooperation, his character, his role as compared to others. Is the way in which it was expressed by Mr. Devaney. We do have a concern at the way in which Mr. Devaney approached the visit on the 5th of April, in which Mr. Devaney suggested that this was not a, I'm sure he made a mistake and didn't mean to do it, but he was suggesting that this was a visit that was somehow without the offer of a benefit. I'm sure he didn't mean to go behind the facts that are agreed, that the whole course of the conduct is on the basis of the offer of a benefit and not of a threat. And I'm sure he didn't mean to suggest that Mr. Bahtijari was threatening witness one in any way. So assuming what he means is that the follow-up was the detail of the offer of a benefit, then we make no alternative submission. We are grateful to the prosecution of recognising the fear and concern on Mr. Bahtijari. We are grateful for the prosecution recognising that Mr. Bahtijari is a sympathetic character. We submit that the information that you have in relation to the connection between the issues that are raised in terms of medical matters, which I'll ask for private session in a moment, do satisfy the relevant legislation for you to conclude that Mr. Bahtijari was substantially diminished. Accordingly, I submit that we're not very far apart with the prosecution, but a few months to Mr. Devaney may not be very much, but it's an extraordinarily long period of time over this particular seasonal break where every other family in the world will be having some form of celebration, whatever their religion. In our submission, it is a long period of time for Mr. Bahtijari. If I might just finally go into private session and deal with one or two other matters.
Madam Court Officer, can you bring us into private session, please? And you will explain to us why we have to be in private session as soon as we are there. Yes, very well.
Sorry.
Your Honours, we're in public session.
Thank you. Defence Counsel, you have the floor.
Thank you. Two final matters to respond. In terms of the language of pervasive and chilling, we dealt with that at the outset of our submissions on the question of general deterrence. We have accepted that this is a case where general deterrence will be applicable. We say that that is encapsulated by the plea agreement in relation to Mr. Bahtijari, and we repeat our submissions that there is no need for specific deterrence. So that language of pervasive and chilling need not be applicable or applied by you to Mr. Bahtijari. Overall, we finish with this. Mitigation matters. It really, really matters in these courts, perhaps more than any other court, that there is a recognition that there is a need to understand people in the places that you adjudicate over, to understand them, their families, their health, their communities, and to understand how sentences can be properly mitigated for poor sick old men acting under direction. For all the reasons that we have set out in public and private session, this case is emotional for a reason. And it's emotional for a reason because he shouldn't be here any longer, or at least any longer than possible that it takes for you to make a decision in his case. Those are our submissions. Thank you very much.
Thank you, Defence Counsel. For Mr. Prosecutor, do you have any submissions, additional submissions in reply to the Defence Counsel?
Nothing further, Your Honor.
Thank you. Then we proceed with a last part of this hearing with regard to the plea agreement of Mr. Bahtijari. Defence Counsel, in paragraph 63 of the sentencing submissions, bearing filing number 620 core, you state, and I quote, that the guilty plea suggests, emphasis put on the suggests, that Mr. Bahtijari understands the wrongful nature of his conduct and is unlikely to reoffend, removing the need for specific deterrence through sentencing. And I noted that you indicated that Mr. Bahtijari is not going to make a statement with regard to sentencing.
No.
No. I will anyway ask him the question, and he's free not to answer it. And if you want to confer with your client, just to give him a heads up on this, or if you want to, then you are free to do that.
I don't think I need to, because he was very firm that he did not wish to speak to the court at all. But I understand that
on this,
on any topic, but on this, including this topic. But I understand that you will ask him the question. If he appears unable to answer, then I will ask for time to speak to him. But I believe you can ask the question.
Mr. Bahtijari, I have a question for you, but you are, of course, under no obligation to answer them. And I would like to ask you, Mr. Bahtijari, if you feel any remorse in the sense that you feel sorry for doing what you agreed on in the agreed facts. Did you think that it was wrong or bad?
Popo.
Yes, yes.
Yes, what?
Popo.
Popo?
You asked if it was wrong or bad. I would infer that he is agreeing that yes, it was wrong and yes, it was bad.
But then I will ask them, and I want to be sure what I
understand.
Do you confirm that what you did was wrong? Is that what you're saying? I don't want to put words in your mouth, but are you saying that you now consider that it's wrong what you did back then?
That's correct.
And would you like to say something more about why you think that it is wrong? Mr. Bahtijari, did you hear my question?
I heard your question, but I'm not able to answer.
Then we leave it to this, Mr. Bahtijari. If there is nothing else with regard to the plea agreement that parties would like to raise with the panel, I look at the SPO.
No further argument, Your Honor.
And defense counsel, is there anything with regard to the plea agreement that you would like to raise?
No, thank you.
Very well. Then this concludes, Mr. Bahtijari, the hearing on the plea agreement entered between you and the Specialist Prosecutor's Office. As announced earlier, there is a wrap-up session, and for the panel, there's only one issue we would like to clarify or resolve. So we could do that now, but we can also reconvene in half an hour. So unless the parties indicate that there are further issues we need to discuss, because then we need to have a break, and because I don't want to prolong this hearing, which has already taken 2 hours, and we ourselves, but the translation, the interpretation booths are working at full speed. So,
might I jump up first and hope that everybody could deal with it now? I don't want to cause Mr. Bahtijari much more delay, and I think having a break and coming back for him might be quite hard. So if everybody can manage now, I'd be very grateful if we could just carry on. I don't anticipate any of us will speak for terribly long.
Okay, you have spoken for yourself.
Thank you. I understand that.
Thank you. Thank you very much, and it's noted.
Thank you.
I go to the defense for Mr. Januzi.
We're in the court's hands.
Thank you. Mr. Catman.
I would ask that we continue now for as long as it is necessary to complete the session.
Okay. Thank you very much. Specialist Prosecutor's Office, what is your position?
Yes, we would also like to continue now, Your Honor.
Okay, very well. Then we continue. Yes. Mr. Bahtijari, bear with us a little bit more. We are going to proceed with the last part of this hearing, which will be for all defense teams. Very well. There is one issue that is regarding the reclassification request made yesterday by the defense for Mr. Januzi. It regards filing 612, Annex 1. And specifically during yesterday's hearing, the Januzi defense, and I noted that the defense was joined by the other defense teams, they asked the panel to reclassify as confidential Annex 1 of 612, and there were also some requests related to it, which was not reclassification, but a summary of the annex. And we heard the submissions of the Specialist Prosecutor's Office pursuant to said annex, and there was also a request to have a public redacted version of that annex, or a summary. The panel has taken note of those submissions made by the Januzi defense in this respect, the submissions of the SPO, the H.Shala defense, and the Bahtijari defense. we refer to page 526 till page 531 of the transcript of yesterday's hearing. And what we note is that in this regard, that the SPO submissions in response to the panel's requests in Annex to filing 612 are to be found in paragraphs 15 and 16 of the SPO filing 618, which is classified as confidential. And thus all parties have access to it. And as a result, the panel finds that it is no longer justified to maintain the current classification of Annex 1 to filing 612, as its contents have been shared already with the defense. So, accordingly, the panel will proceed to reclassify the annex by lifting the ex parte marking, unless the SPO wishes to object to said reclassification. And if there is an objection, then we will proceed with written submissions, and I will give deadlines for the Special Prosecutor's Office and then for the defense teams.
May I have a very brief moment to confer with my colleague?
Of course.
Your Honor, I can confirm that the SPO has no objection to the course Your Honor proposes.
Thank you very much. And that will mean that we instruct the registrar to lift the ex parte marking from filing 612 Annex 1, and it concludes our oral order.
We do have an additional submission we would like to make before we close out today's session. Happy to do so now or at a later moment, as Your Honor prefers.
Yes, you may proceed in order to wrap up now. So, and can this be done in public?
Yes.
Very well. You have
Yes.
the floor, Madam Prosecutor.
The SPO has reflected on what has occurred in the hearings of yesterday and today, and in particular, the indication from the panel with at least regard to paragraph 12 of each of the plea agreements that certain further amendments would be recommended by the panel. We've conferred with our colleagues in the defense, and the SPO has certain submissions, in particular that it's our position, a shared position with the defense, that no change is actually required to the plea agreements because, including in paragraph 12, they have been carefully designed in order to cover all eventualities, including the one that we find ourselves in as addressed by the court in colloquy with the individual accused when going through paragraph 12. We see, in addition, that there may be unnecessary and potentially significant complications arising from the creation of new plea agreements following the entry of the guilty pleas by the accused yesterday and today. Each accused has confirmed the scope of their pleas and their understanding of the consequences of entering the pleas in court this week. Clearly, that is on the record, and our position is that nothing further is needed. In addition, the status of any further plea agreement entered into after the accused have already pleaded guilty and how the panel would satisfy itself that those new agreements comply with Rule 94 without redoing the entire proceedings that took place yesterday and today would seem to be very unclear. It is therefore the SPO's submission, and as mentioned, this has been discussed with my colleagues in the defense, and my understanding is that they join us in this. It is our position that nothing further is required, and that doing more at this point may in fact introduce unnecessary complications to future procedures. That's all I have for Your Honor.
Thank you very much, Madam Prosecutor. From the side of the defense teams, is there something you would like to add to this apparent common position?
Only to say that it is indeed a common position. We join it.
Very well, thank you. Defense counsel for Mr. H.Shala.
Having discussed it with the SPO this morning, we concur.
Okay. Thank you very much.
Same.
This is noted. Yeah. The panel will give further instructions after the judicial winter recess as soon as possible. There's something you want to say, Defense Counsel. I understood that we were wrapping up. You have the floor.
Yes, I do have two matters that I'd like to raise as part of the wrapping up session. The first matter is that acknowledging the timetable that the court set down for contact with the VPO yesterday, I nevertheless request the trial panel to move to an issue on the decision to approve the plea agreement and impose a sentence in accordance with the recommendations in the plea agreement, less with credit for time served, as soon as possible. And I would urge, if possible, that decision to be before the end of this term. The issue of the applicability or otherwise of reparations is, it seems to me, an entirely separate matter. And the decision as to approval of the plea agreements and sentence should not wait for the reparations issue to be resolved. We note that in the cases of Mr. Salim Mustafa and Mr. Peter H.Shala, cases 06 and 05 respectively, the court did indeed proceed to sentence and retain jurisdiction to deal with the issue of reparations at a later date. And I exhort the trial panel to take that course in the present cases, particularly given the scope of the plea agreements and the terms of imprisonment that are considered therein, and the fact that the defendants have, of course, spent a significant period of time in custody already. In relation to the second oral order that Your Honour made yesterday, dealing with that timetable for contact with the victim's participation offer, it was part of that order that the victim's participation office was to be provided with the what we were referring to as the 6th of December 2024 version of the indictment. That oral order was issued by the trial panel, of course, before that 6th of December 2024 version of the indictment was effectively set aside, and it has, in accordance with that decision of the trial panel, not featured at all. It has not been used properly during the course of these plea hearings, and it would be my submission that that document should not be provided to the victim participation office in these circumstances. It only risks creating, it gives them a document that hasn't in fact been used, and only risks creating a degree of confusion at the victim's participation offer. So I would ask that the court considers amending its earlier oral order yesterday, just in that limited respect. It was part of the second oral order that you ordered, Your Honour, that the Victims Participation Office be provided with the 10th of July 2024 indictment together with the plea agreements. And of course, those are the two instruments, as it were, that have been used during the course of the plea hearing. I take no issue with that. They would then have everything they would need and do not need to have the document that has not been used accordingly. Those are my two submissions.
Thank you, Defence Counsel. Defence Counsel for Mr. H.Shala, is there something you would like to submit to the party, to the panel?
Just to say that I fully support both requests that Mr. Rees has made. Obviously, this term effectively ends tomorrow. I understand that gives you limited time by which to comply with the first request, and it would appear that the 17th of January would be the first next available court date after the winter recess. We would only urge that, as this is a matter which is going to be dealt with by way of a written order, that is communicated to the three accused as soon as is possible. Not to put these matters to the end of January, I think would be unfair to the three accused, and would be inconsistent with the efforts that have been taken to agree these plea agreements. So I would only urge Your Honours to issue your written order as soon as possible, and then schedule the hearing on the first available court date, which would be sometime after the 17th of January.
Your submissions are noted, Defence Counsel. Defence Counsel for Mr. Bahtijari.
I think I've already made my position clear, but the application is supported.
Very well. What we will do is, I noted that the prosecution has made all the submissions it wanted to make in this respect. Would you like to further react to the submissions of Mr. Januzi, of the defense for Mr. Januzi?
Very briefly, Your Honor, just to say that we've heard the defense submissions and we would join our colleagues in agreeing to the same.
Very well. What we will do is that we will now adjourn for half an hour to discuss on this matter. And also that I think we are now at a moment that we need to take a break for all people that have been working since 1 o'clock till now. What we can do is that Mr. Bahtijari can be excused for the second part, and then we see each other back at 3:45.
Can I just understand that he doesn't need to come back at all and he can be returned to the detention centre? Is that what you meant?
That's the meaning of that he is excused for the next session.
And
yes.
would you mind excusing me? Co-counsel will be here.
That's your choice. She can as well represent your client as you can. So that's in our rules, in our regulations.
I'm very grateful indeed. Thank you very much.
Good. Then the hearing is...
Your Honour, sorry.
Yes.
Would you also consider excusing Mr. Januzi from the returned hearing?
He may, if that is his wish, then we can.
I think he would rather us deal with administrative matters in his absence.
We can proceed in that way.
Thank you.
Very well. Then the hearing is adjourned till 3:45.
All rise. All rise.
Welcome back. For the record, I will see who's present and if there are any changes. Specialist Prosecutor's Office, you have the floor.
Tasneem Shahabuddin, prosecutor for the Specialist Prosecutor's Office, and I'm joined by Deputy Specialist Prosecutor Bart Ferdinand Dusa, Associate Prosecutor John Devaney, and Case Manager Lena Peterson.
Thank you very much. On my left-hand side, the defense team. The defense for Mr. Bahtijari. Could you indicate who is present now?
Sorry, Your Honor. Joining us remotely is our administrator, Katie Delany, and in the courtroom, Ms. Hu Chin-Liu, Associate Legal Officer, and I'm co-counsel Marion Carroll. Thank you.
That last, I did not hear. I did not hear what you say.
Sorry?
I did not hear the last words.
Oh, sorry, and I am co-counsel Marion Carroll.
Okay. Is there a special reason that we are looking at a screen without visualization of the person? Oh, yes, very well, because we could not proceed in that way. The defense for Mr. Januzi, could you indicate who's present?
Your Honour, the representation for Mr. Januzi remains as per the earlier sessions today. The only difference is that Mr. Januzi himself is not present online as he was earlier in the morning.
Thank you very much. And we note that the same goes for Mr. Bahtijari. He is not present and both have been excused. And then the defense for Mr. H.Shala, you have the floor.
No change in the representation for Mr. H.Shala.
Thank you very much. There were two outstanding issues, and I will deal with them now on behalf of the panel. As regards the oral order on reparations issued by the panel on the 18th of December 2024, yesterday, the panel clarifies that the Victims' Participation Office should receive the confirmed indictment of the 10th of July 2024, which is filing bearing number 3799 Annex 1, and not the 6th December 2024 confirmed indictment, which bears filing number 619 Annex 1. Yes. The panel further clarifies that the plea agreements also, that are public now, also need to be transmitted to the Victims' Participation Office. The panel also wishes to clarify that it will only be in a position to decide on the plea agreements, including sentencing, following the report of the Victims' Participation Office. And that's but for 20 January 2025, and observations of the parties on that report that was set for the 27th of January 2025, as the issue of reparations, if it arises, has to be dealt as part of the plea agreements pursuant to Rule 94, Paragraph 2, under C of the rules. And the panel will also give further instructions in due course after the judicial winter recess. These were the clarifications of the panel. And I thank again the parties for their participation and all the colleagues of the different units of the registry for their assistance. The hearing stands adjourned.
All right.